A public row between President Uhuru Kenyatta and Chief Justice David Maraga escalated today, with Attorney General Kihara Kariuki accusing the Supreme Court President of grandstanding, hero baiting and playing to the gallery. At a press conference in which he declined to take questions, Kihara accused the Chief Justice of launching personal attacks against the President and prosecuting cases involving the executive before the public. Let's get more details from Sam Ogina.
Flanked by State Law Office staff, Attorney General Kihara Kariuki stepped forward to defend President Uhuru Kenyatta from Monday's blistering attack by Chief Justice David Maraga. The standoff between the President and the Chief Justice stems from the delayed appointment of 41 judges, but the Attorney General claims the standoff has gone personal and the matter is before courts.
Of particular concern is the fact that these emotive and highly charged public attacks by the Honourable Chief Justice have now taken a decisively personal slant.
The President's refusal in appointing the judges is pegged on alleged National Intelligence Service reports that question the integrity issues on some of the appointees. But the Chief Justice seemingly doubts the intelligence report's narrative.
Some of the individuals the executive claims to have adverse information against are serving judges.
His Excellency the President will not abdicate his role as head of state and government to appoint persons with a questionable record to serve the nation in the solemn role of judge.
In what is shaping up as a public spat between the executive and the judiciary, the Attorney General is now accusing the Chief Justice of setting a bad tone for magistrate and judges who are going to sit here and determine cases from the executive. The AG nearly falling short of accusing the CJ of influencing the cases beforehand.
The Honourable the Chief Justice is openly commenting on the relative merits and demerits of cases involving the executive, which are still pending in the courts. This not only creates a perception that the Honourable the Chief Justice is seeking to influence the outcome of these cases, but also raises questions as to why he, as a Justice of the Supreme Court, is expressing extrajudicial opinions on matters that may end up in the Supreme Court for hearing and determination.
The High Court, in petitions filed last year by David Kariuki Ngari and Adrian Kamotho Njenga, ordered the President to appoint the 41 nominees within 14 days, pointing out that he had no constitutional mandate to question or reject names recommended to him by JSC. The CJ accusing the AG of filing appeal notices and going into hiding. In a rebuttal, the AG is accusing the courts of stalling the process by holding on to crucial court proceedings for nearly 4 months, documents that would enable him file the appeal.
Government is a calling to public service and delivery for the benefit of the people of Kenya, not grandstanding and playing to the gallery for hero status.
The intensifying tug-of-war between the executive and the judiciary translating into case backlog. For instance, in the Environment and Land Court, there are 16,457 pending cases as at March this year that must be handled by 33 judges. The Employment and Labour Relations Court has 13,197 pending cases that must be dealt with by 12 judges. The Appellate Court has 7,315 unresolved cases as at the end of March, with 15 judges on the list.
The Constitution does not donate any mandate to the President to perform any other act upon receipt of the names recommended by the chairs, except to appoint them.
We invite that office to focus on reopening access to justice, eliminating the inordinately high levels of backlog of cases, and addressing the concerns of litigants over the administrative barriers that constrain their ability to be heard by the courts.
The AG defended the executive, saying it is not subverting the law by ignoring court orders, and instead termed the CJ statement as unsubstantiated and emotional. Sam Ogina, Citizen TV, Nairobi.